Hello, in this presentation I want to provide an outline of the law applicable to the exploitation and exploration of the continental shelf and its resources. And what we're going to do is first look at the origins of the continental shelf as a concept, then we'll look at the 1958 Geneva Convention on the continental shelf. We'll then explore the definition of the continental shelf under the UN Convention on the Law of the Sea, and then look at two further issues about the extent of the continental shelf. First, the possibility of overlapping claims in practice, and second, the outer limits of the continental shelf beyond 200 nautical miles, and how that relates to the regime governing the deep seabed area, and the creation of the Commission on the limits of the continental shelf. So let's start with our history. So the origin of the continental shelf in modern international law begins with the proclamation of President Truman in 1945, made in these terms, that the government of the United States takes the view that there should be further exploitation of petroleum and other resources found on the continental shelf, that such resources are more possible than ever to utilise as at 1945, given advances in technology, and therefore in order to efficiently use and protect the conservation and exploitation of these resources, there should be jurisdiction given to the coastal state. So in light of these considerations, the United States declares it will adopt a policy whereby it will regard the natural resources of the subsoil and seabed of the continental shelf beneath the high seas but contiguous to the coast of the United States as appertaining to the United States and subject to its jurisdiction and control. So the United States is the first state to openly assert jurisdiction over the resources of the continental shelf. But it doesn't do so out of the blue. Before the Truman Proclamation is made, the US government consulted with a number of its friends and allies, particularly those who were similarly placed in terms of continental shelf resources, and said, when we do this, what will your reaction be? And other states essentially said, we have no objection and expect we may well wind up doing the same thing. And very rapidly, other states did assert jurisdiction in some form over their continental shelf. So whereas we normally talk of customary international law in formal terms as requiring state practice that emerges over a long time based on the belief that it's required by law, this is the classic example of a state instead really sort of putting on the table a proposed rule and saying, if we do this, will you follow? And one of the key tests of whether something is a plausible rule of customary international law or likely to become customary international law is to say, well, does it benefit more than one state? Does it benefit a class of states? And obviously the idea that you might have resources in your continental shelf benefits every state with a every coastal state with a continental shelf. So this fairly rapidly leads in the 1958 conventions to the Geneva Convention on the continental shelf. And our essential question here is, well, under the 58 Convention, where did the continental shelf end, and what were the problems with the definitions of its limits? So a key issue we're exploring here throughout all of this material is, to some extent, not just what powers do you have over your continental shelf, but also where does it end? Because if we're assigning, as it were, property rights in the shelf, that's an important consideration. So Article 1 of the Convention said, for the purposes of these articles, the term continental shelf is used as referring A, to the seabed and subsoil of the submarine areas adjacent to the coast but outside the area of the territorial sea, to a depth of 200 metres. So that's an isobath, a line joining points of equal depth, the 200-metre isobath, or beyond that limit to where the depth of the superjacent waters, the waters above, admit of the exploitation of the natural resources of said areas, and to the seabed and subsoil of similar submarine areas adjacent to the coast of islands. So two ideas here. One, islands generate a continental shelf, as we've seen in our previous presentation on the exclusive economic zone. But more importantly, your continental shelf extends either to the 200-metre isobath or as far as you can actually exploit. Now, that exploitability criterion is, on its face, completely open-ended. And in theory, for example, you could have the states of Western Europe setting out from one side of the Atlantic and Canada and the US setting out from the other, and dividing the entire seabed as technology got better and better and you are able to extend further and further your jurisdiction. So on its face, the criterion would appear completely uncertain, which isn't helpful if you're trying to create rights of management. Some writers have suggested that it was never intended that that criterion should allow a continental shelf claim to extend beyond where there was physically or scientifically a continental shelf, but on its face that is not what the article says. If we look at Article 2, the coastal state exercises over the continental shelf sovereign rights for the purposes of exploring and exploiting its natural resources. So that is the language we now also find used in UNCLOS in relation to the exclusive economic zone. The rights referred to are exclusive in the sense that if the coastal state does not explore the continental shelf or exploit its natural resources, no one else may undertake these activities without consent. So the rights aren't contingent on occupation or use. They simply exist. They adhere in the coastal state automatically. And that point is further reinforced by paragraph 3. And then paragraph 4, the natural resources referred to in these articles consist of mineral and other non-living resources of the seabed and subsoil, together with living sedentary species. So these would be things like lobsters or other crustaceans that live continuously on the seafloor, as opposed to fish which swim in the water column. Now, one thing that we need to note here that I have not put up in any great detail, because the provisions really should be read for themselves, are Article 5 of the 1958 Geneva Convention on the Continental Shelf and Article 60 of UNCLOS. You should read both of these articles side by side and take some time over them, and note a couple of common features. It is only the coastal state that has the right to create artificial islands or platforms on the continental shelf. In both conventions, 500-metre safety zones can be installed around these platforms. In both conventions, there is a concern that platforms not interfere with freedom of navigation. And let's remember that if we're talking about the continental shelf beyond the exclusive economic zone, then the water column above it is the high seas. And freedom of navigation obviously has very strong protections on the high seas. And even in the exclusive economic zone, freedom of navigation is on its face preserved under Article 58.2. So there are considerations there. And that goes to the point about what one should do with platforms at the end of their useful life. So if we look at Article 5, paragraph 5, you'll note that the Geneva Convention refers to the complete removal of platforms at the end of their useful life. Now, in 1958, when such platforms were likely to be closer to the shore, that might not have been completely impractical or ruinously expensive. But we find rather more flexibility in Article 60, paragraph 5 of the UN Convention on the Law of the Sea, which talks about Article 60, paragraph 5 talks about safety zones. I meant Article 60, paragraph 3 talks about the removal of platforms at the end of their useful life. And it talks about ensuring the safety of navigation, taking into account any generally accepted international standards established by the competent international organization regarding removal, and that will be the IMO. So one should also look at the IMO guidelines on platform removal for guidance as to what should be done at the end of a platform's useful life. Now, Article 6 of the Convention deals with the possibility of overlapping claims and says that, in the absence of agreement and unless another boundary line is justified by special circumstances, the boundary will be the median line. And this is actually the general principle of delimitation in the modern law of the sea, that you start by drawing a median line, a line based on equal midpoints between two coastlines, and then adjust it according to special circumstances. And you're drawing that median line, obviously, from the baselines of the two states with opposing coastlines. All right, so that's the basic law under the 58 Geneva Convention. Let's turn now to the continental shelf under the UN Convention on the Law of the Sea. This is substantially more complicated, and I'm going to be simplifying to some extent the relevant provisions of Article 76, which lay out quite a complex definition. But let's go through it as best we can. Now, the first question is, well, why was the breadth of the continental shelf a controversial issue in the negotiation of UNCLOS? Everyone could agree that the definition in the Geneva Convention wasn't particularly satisfactory because it was potentially open-ended, so one needed a limit. But at the same time, one of the ideas that kicked off negotiations for UNCLOS was, how will we manage the potential wealth of the deep seabed beyond national jurisdiction? So here's the thing, the wider and wider one makes the continental shelf, the more you are potentially subtracting from the area which was to be subject to international management as part of the common heritage of all mankind, and which was meant to benefit in particular developing states. So developing states and landlocked states, or states without extensive continental shelves, were all interested in maximising the extent of the area left beyond national jurisdiction. At the same time, states that had wide continental margins wanted to be able to exploit all of their continental shelf. Other states, even coastal states with narrow continental margins, said, well, why should we have anything more than the exclusive economic zone? We should just have a simple, uniform 200 nautical mile cut-off rule and no separate regime for the continental shelf. But of course the negotiations were by consensus. So it was very difficult to get states to give up, individual states or groups of states, to give up things they already thought they had. So the question was, well, how do we strike a balance between preserving as much of the deep seabed as possible, on the one hand having a uniform 200 nautical mile rule, but on the other hand allowing states with broad continental margins to maintain their existing claims? So my question is, if we were looking for a customary rule, we have to ask, what is the simplest and clearest definition of the outer edge of the continental shelf? Where does it end? And then what are the limits under the convention? So here's what I would suggest is the critical paragraph. Article 76.1. The continental shelf of a coastal state comprises the seabed and subsoil of the submarine areas that extend beyond its territorial sea throughout the natural prolongation of its land territory. So this is different than the Truman Proclamation formulation. This is a statement that the continental shelf is the natural prolongation of land territory, and therefore one should have sovereign rights or jurisdiction over it. And the critical phrase is to the outer edge of the continental margin or to a distance of 200 nautical miles. Now that's simple and clear enough that it probably qualifies as the customary rule from the baselines from which the breadth of the territorial sea is measured. Now, the continental shelf is then subject to a range of limits found in paragraphs 4 to 6. So we have this general definition, the outer edge of the continental margin. But the question is, what does that mean? So the continental margin may mean something different to a scientist than to a lawyer interpreting the Law of the Sea Convention. And paragraphs 4 to 6 set out effectively a mixed scientific legal formula for where the continental shelf should end. And here is a diagram that's quite useful in this respect. So the scientific definition of a continental shelf would normally stop at the slope, but the definition under UNCLOS will include part of the rise as well, beyond the continental slope. And there are two rules here. You can draw a line based on the foot of the slope through to a point where the sedimentary thickness is equal to 1% of the maximum change in gradient. There's no need for you to memorize that for the purposes of this course. Just accept that one can draw a line joining up such points. It's marked in green as foot of slope plus 1% of sedimentary thickness. The other one that's easier to wrap one's head around is the idea of the foot of slope plus 60 nautical miles. Now the thing is, you don't have to choose one line or the other. You can use the maximum extent of both, which is what the dotted line on the image portrays. The foot of slope up to a certain point, then the gradient change line where that extends further than the foot of slope plus 60 nautical miles. Now, there's then a question of, all right, that is the prima facie definition of the continental shelf as a matter of law, and beyond that lies the area. But what if this gives you an extraordinarily large area? Are there certain limits? And the answer is yes. Your continental shelf cannot extend beyond certain constraint lines set out under Article 75.5. And those two constraint lines are effectively the greater of 100 nautical miles from the 2,500 metre isobath. So that's a line in the sea joining points of 2.5 kilometres depth, or 350 nautical miles from baselines. So what I've attempted to do is illustrate this sort of on the left. You might have a continental margin that extends out as far as the line I've got in light blue. Then, and that extends beyond, in my little diagram, the red 200 nautical mile limit on your EEZ. So then you have to say, oh, but are we entitled at law to all of that? And first one might draw the 2,500 metre isobath and add 100 nautical miles, and you get the green line. And so that would cut off potentially some of your continental shelf, but the question then is, well, where does the 350 nautical mile line fall? And in my diagram, it falls further out. So you're entitled to take the rule that leaves you, as it were, the most, and that results in the diagram on the right. So you've created a continental shelf in accordance with the rules up here, but you've then overlaid the two constraint rules. You've chosen the greater of them, in this case 350 nautical miles, and that cuts off some of the continental margin you might otherwise claim. Now this is quite complex, but it's made more complex by the fact that in the case of a submarine ridge, as opposed to certain other types of submarine features such as elevations, you can only claim the 350 nautical mile line, not the isobath based line, and in some cases that might get you less of the continental shelf. So this simply reflects that in some cases certain elevations on the continental shelf might be treated as potentially extending the shelf further or not. Alright, there is no need to understand this in great technical detail, but this gives you a flavour of the complexities involved. We then have to note that a number of rights are guaranteed to the coastal state. These largely mirror the kind of rights we've already discussed in relation to the continental shelf. And in terms of the rights guaranteed to other states, one should just note that Article 78 deals with the fact that the waters above the continental shelf are not affected, or rather, the possession of a continental shelf doesn't of itself affect the status of the waters above. They will either be exclusive economic zone, territorial sea, or high seas, and that's where we look for the rules about what you can do above a continental shelf. the fact of the continental shelf, title in the continental shelf doesn't affect rights in the water column. And Article 79 makes the point that that other states have the right to lay submarine cables and pipelines on the continental shelf, subject to certain limits specified in Article 79. Okay, now we then come to our next question, which is, what do you do where potential continental shelf claims overlap? Because geologically, a number of coastal states might sit on the same continental shelf, or you might have island states, as it were, facing each other. How do we divide up continental shelves in these cases? All right, so we saw that in respect of the Geneva Convention, there was a reasonably straightforward rule. The Geneva Convention, Article 6.1, as you'll recall, referred to median line adjusted by reference to special circumstances. Article 83.1 of UNCLOS simply says that the delimitation shall be effected in accordance with international law, which in practice is going to mean equidistance plus relevant circumstances. There was simply some controversy over the extent to which this was somehow a new rule in relation to a new definition of the continental shelf, and rather than resolve the controversy of the principles that should be used in determining how to divide up a continental shelf, it was easier for the convention simply to say the rules of general international law will apply. Now, going back to some of those questions about the outer limit of the continental shelf, one of the useful things here to look at is the Durham University International Boundaries Unit map of the North Pole and potential claims. Now, you can look at it in your own time. I'm just going to highlight a few points of particular interest. So if we go in and zoom in a bit towards Canada, so we've got north of Canada here, you'll see this dark green area is their exclusive economic zone out to 200 nautical miles. This shaded area is potentially claimable geological continental shelf. The dotted line is the median line between Canada and Russia. Here we have the Lomonosov Ridge, which has proved controversial in discussions about the extent of the Russian continental shelf. But what I want to draw attention to are these features here. This black line is 350 nautical miles from Canada's baselines, and this blue line represents the 2,500 metre isobath plus 100 nautical miles. So the potential, so one way of thinking about this is the cross-hatched area is perhaps all of the physically existing continental shelf for Canada, stretching up towards the North Pole. But then you're only going to get the 350 nautical mile or the isobath baseline, whichever is greater, and that would leave you with a limit that would come out like this. But to the point where it crosses this dotted median line, you're going to have an overlapping claim potentially with Russia. Then down here you can see where various cross-hatched areas overlap in terms of different states and their possible claims. So the map is fascinating and well worth looking at to try and pick apart what it tells us about how big a continental shelf might be according to the rules under UNCLOS, and where some of the overlapping claims might be. Now, one case I'm going to look at in a little detail here, though we won't look at it in the same detail in class necessarily, is a case between Barbados and Trinidad and Tobago over the extent of continental shelf claims. So essentially what we're seeing here, Trinidad and Tobago down in the left, Barbados up in the centre, is that the two Caribbean states sit on the same continental shelf, which projects, as it were, out to the east. And this cross-hatched area out on the right hand of the screen is the potential total outer continental margin. But the difficulty that arises is the possibility that beyond certain median lines, there are areas that are within 200 nautical miles of Barbados, but beyond 200 nautical miles from the baselines of Trinidad and Tobago, and that's this cross-hatched area out here. So Trinidad and Tobago's 200 nautical mile line stops here. Below is the negotiated boundary with Venezuela. So Trinidad and Tobago's argument was, look, we all sit on the same continental shelf. We should all get a slice of the pie. We should not be cut off from the continental shelf because we have no corridor to it because of this slice that falls within the jurisdiction, the ostensible EEZ jurisdiction of Barbados. And part of the problem was that Trinidad and Tobago had given up, in a sense, too much in negotiations with Venezuela. This dotted line down here is the median line that it might otherwise have had with its southern neighbour, but you can see that it accepted in negotiations that that boundary was shifted against its interests. So it might have actually had a slender sliver of EEZ or continental shelf out this way, but for that bad deal it had struck with its southern neighbour. So the question then became for the tribunal, well, can Trinidad and Tobago ask to have the continental shelf under Barbados's EEZ? Barbados should get the water column in the EEZ and we should get the continental shelf. So the argument being everyone should be entitled to a slice of this continental shelf, and the continental shelf actually exists. The EEZ's merely a legal construct. So the fair thing to do is to give us a slice of the continental shelf, but give Barbados EEZ rights in the water column. That argument was not accepted by the tribunal. The tribunal came up with a single maritime boundary line shown here in purple, and the net result of that is that Trinidad and Tobago does not get a continental shelf beyond 200 nautical miles. The EEZ was not, Barbados's EEZ claim was not somehow inferior to an actually existing continental shelf, and because the rights, obviously, contained in the EEZ regime and the continental shelf regime are the same with respect to the seabed and subsoil. So Trinidad and Tobago lost out in that case and did not get a continental shelf beyond 200 nautical miles, even though there was continental shelf, as it were, out there to be claimed. Now, all of this raises the question, well, it can be quite controversial how you might divide up continental shelves or exclusive economic zones. What can states do in the interim? And Articles 83 and 74 of the UN Convention on the Law of the Sea talk about entering practical arrangements of a preliminary nature to allow the exploitation of the resources that may be out there. So one example might be that you could have perhaps an oil or gas field that was going to wind up straddling a border no matter where it was drawn, and what can happen is a unitization agreement. So essentially, if there's one pool of, say, natural gas that two states are both exploiting, the amount taken out can be measured and recorded, and then when eventually delimitation is settled, one can work out, as it were, how much of the oil or gas field fell either side of the line, and if one side has extracted perhaps more oil or gas than they're due, the other side can be compensated. So everyone extracts the oil and gas, and then, as it were, you adjust the profits later. That's one possible example. Okay, let's move on to the final issue. Now, there was some controversy about, well, we have all these complex rules that we've discussed over here about, in my sort of point 3, about how you define the outer continental shelf. But if states are just allowed to do this completely independently, who's going to guarantee that they've applied the rules correctly or fairly to the extent that there's any wriggle room in how they should be applied? So one question here is, well, we start with the 200 nautical mile limit, and that could, encompass quite quite some extent of a state's coastal territory. But the point about beyond your continental shelf beyond 200 nautical miles is that while you get exclusive rights to exploit them, you have to pay royalties to the International Seabed Authority. Now, these are fairly modest royalties, but the essential idea here is it's a compromise. The continental shelf beyond, the seabed beyond national jurisdiction is managed by the International Seabed Authority as the common heritage of mankind for the benefit of all states. Within 200 nautical miles, you have completely exclusive control as the coastal states. So the compromise was, on your continental shelf, defined under Article 76, but beyond 200 nautical miles, in that space, the coastal state still has complete control, but royalties will be paid to the International Seabed Authority, fairly modest royalties. So this was part of the grand compromise between states who thought there should be a hard 200 nautical mile cut-off rule in the definition of the continental shelf. So knowing where your continental shelf completely ends and how much falls between that outer continental margin, the 200 nautical mile limit, is significant in theory on this issue of royalty payments, although effectively no exploitation occurs that far out to sea yet. So the question then becomes, well, how do you do this? So Article 76.8 says, information on the limits of the continental shelf beyond 200 nautical miles from baselines from which the breadth of the territorial sea is measured shall be submitted to the coastal state to the Commission on the Limits of the Continental Shelf, set up under one of the annexes to the Convention. Then that Commission shall make recommendations to coastal states on matters related to the outer limits of their continental shelf. So the coastal state puts information to the Commission, and the Commission sends recommendations back. The critical sentence then is, the limits of the shelf established by a continental state on the basis of these recommendations shall be final and binding. So this is what's been called by Dorman a kind of ping-pong process. The coastal state can put up submissions, they then get recommendations back. If they adopt those recommendations and proclaim their outer limits on the basis of them, then those limits are final and binding. Now, Dorman's analysis of the Commission is excellent, other than the bit where he says the only state who is finally bound by Article 76.8 is the coastal state itself. This makes little sense. Why would a coastal state submit to this procedure just to have their claim sort of finalised, binding only them? The more usual interpretation is that once you've proclaimed limits in accordance with the recommendations of the Commission, then those limits are final and binding on all other state parties to UNCLOS, because then you have certainty. You know where the continental shelf within national jurisdiction ends and where the area managed by the International Seabed Authority begins. Now, part of this push for legal certainty was the idea that there should be time limits on making submissions to the Commission. But for a number of reasons, it proved difficult for less developed states to make complex geotechnical submissions about their continental shelf. The Commission was very slow to be established. It's an elected body of technical experts, not legal experts, and also it has been quite slow in fulfilling its mandate. So originally, for those states that were party to UNCLOS as soon as it came into force in 1994, the time limit should have run out in November 2004. You get 10 years from when the clock starts. You get 10 years and the clock starts running from the moment you become bound by UNCLOS. So new states as they join get 10 years to make a submission. But then in 2001, a meeting of the state parties to the Law of the Sea Convention passed a Resolution 73, S+73 of 2001, which said, well, given that it took us a while to get the Commission set up, in fact about 5 years, we should have a 10-year limit from 13 May 1999. You shouldn't be obliged to submit to a Commission that hasn't yet published its rules of procedure. But states, particularly developing states, became quite clear weren't even going to make that extended deadline. So Resolution 183 of 2008 simply says, look, even though the Convention and Annex 2 says that you're meant to be making a sort of proper submission to the Commission on the limits of the continental shelf. Just sending us preliminary information about where you think your outer limits are will stop the clock from running. So the time limit provision is essentially completely vacated by Resolution 183, which is quite interesting because this circumvents the procedure for amending the Convention, which is otherwise a complex and difficult process. So while there are ostensibly time limits around making submissions to the Commission, in practice all you need to do is get preliminary information in. Now, the Commission has been somewhat controversial. It's a body of technical experts, but using a highly legal definition. And 2 points on which it's been particularly controversial. First, under the Annex to the Convention, which sets up the Commission and sets out the basic rules governing it, it says, the actions of the Commission shall not prejudice matters relating to delimitation of boundaries between states with opposite or adjacent coasts. Now, as a lawyer, what I would take this to mean is to say, well, the Commission is there to tell us where the outer limit of the continental shelf is, not where we might find the lateral limit between two states, or the lateral boundary. So you can delimit a continental shelf without having to divide it amongst adjacent states, or states with potentially overlapping claims. So it's up to the Commission to draw the maximum possible claim, then it's up to states to negotiate how they're going to divide that pie. The Commission has not taken that approach. What the Commission has said is, any time we're notified by states of a delimitation dispute, we will not make any recommendations about where the continental shelf limits are in that area. In fact, it basically freezes dealing with that component of the submission. And that has been very heavily criticised in the legal literature as something that's basically unproductive and gives intervening states a sort of right of veto over other states' continental shelf submissions and defeats the basic aim of the Commission, which is to ascertain the final extent of the area beyond national jurisdiction. The other thing is that the Commission has been very keen to kind of take its own approach to, how to put it, prioritising geological reality over legal rules. So one of the things that the Convention allows you to do in drawing the outer limit of your continental shelf is to use 60 nautical mile straight lines joining two legal points which satisfy one of the rules. That could lead to this sort of area, where you have a sort of geological continental shelf or margin here in green, or that satisfies certain basic principles about being 60 nautical miles from the foot of the slope. And that would suggest that this area A is deep seabed and belongs to the common heritage of mankind and should be left to the management of the International Seabed Authority. But what if you can enclose it with a 60-mile joining line? As a matter of law, looking at Article 76, this seems to be fine. And it doesn't matter that geologically or geomorphologically this looks like you're enclosing part of the seabed and, as it were, taking something. The rules let you do this, you can do this. The continental shelf is a legal construct, it's not about geological reality. The Commission has not taken that view, and the Commission has said this kind of line joining is impermissible. It doesn't respect a distinction between the real continental shelf and the deep seabed. You can use joining lines if the result, if the result is, these little slices up here labelled Area B are absorbed into your legal continental shelf, but this just looks like claiming something the rules did not intend you to do. So this prioritization of, as it were, the real geology of the continental shelf over the legal definition has been controversial. Because let's remember, if this area A fell within 200 nautical miles, if you had a narrow continental shelf, you'd get it anyway as part of the exclusive economic zone. The law does not prioritise geology or geomorphology in the way that the Commission has perhaps done. And Andrew Surdie has called that the disturbing propensity of the Commission on the Limits of the Continental Shelf to legislate, to prioritise what it thinks the rules should say, perhaps, over what the rules actually do say. So that's my summary for our present purposes of the law of the continental shelf. I hope you found it useful, and I look forward to discussing it with you further in class. Thank you.